Why are PCT national phase deadlines so complex to manage? Imagine trying to keep track of dozens of different clocks, each ticking at its own pace and set to its own time zone. That's what managing PCT national phase deadlines can feel like. The Patent Cooperation Treaty, or PCT, is designed to simplify international patent filing, but once you reach the stage where your application enters individual countries, things get complicated fast. Each country has its own rules, deadlines, and procedures. Even though the PCT provides a single international filing system, the national phase is governed by each country's laws. This means you need to be aware of multiple timelines and requirements at once. The first challenge is the variation in deadlines. The main rule is that you have 30 months from your earliest filing date, called the priority date, to enter the national phase. But some countries want you to do this sooner, like 20 months, or later, like 31 months. Countries like the United States and Japan usually stick to 30 months, but others like Luxembourg or Tanzania have different rules. Keeping track of these different deadlines requires careful planning and often specialized software. Procedural requirements also differ widely. When you enter the national phase, you might need to pay fees, submit translations, or appoint local patent agents. For example, some countries requiring your application to be translated into their official language, which can be costly and take time. Others might need additional forms or specific documents. Missing these steps can mean losing your rights in that country. Fee structures are another hurdle. Each country sets its own fees for filing, examination, and maintenance. These fees are due at different times and can vary significantly. Managing these payments accurately is vital because late or missed payments can lead to abandonment of your application. Local agent appointments add another layer. Some countries requiring you to work with a local patent attorney or agent. Coordinating with multiple agents across different countries can be tricky, especially when trying to meet strict deadlines. Missing a deadline often means losing your patent rights in that country forever. These deadlines are usually strict and cannot be extended, so the stakes are high. You need to be precise and organized to avoid costly mistakes. Since a PCT application can designate over 150 countries, managing all these requirements at once is a big task. It involves tracking multiple deadlines, fees, translations, and legal formalities. This is where good IP management tools and early planning come into play. Deciding whether to pursue an international preliminary examination, which is optional, adds even more timing considerations. It can influence your national phase strategy and costs. From a legal point of view, understanding each country's rules is essential. You need to plan ahead, often starting preparations around 24 or 26 months after your initial filing. This gives enough time to handle translations, pay fees, and appoint agents. Using specialized docketing systems helps keep everything organized. Budgeting for the costs involved in multiple jurisdictions is also important. Knowing the specific laws and procedures in each country helps avoid mistakes that could cost you your patent rights. In the end, managing PCT national phase deadlines is complex because it combines the international framework of the PCT with the diverse and strict rules of individual patent offices. Each country has its own timing, procedural, and legal requirements that must be met exactly to secure patent protection worldwide.